evening, wherever you are. I'm Yuri Nemitz, a managing member at Nemitz PLC, a law firm based in Washington, D.C. This is the fourth of the webinar series dedicated to the problem of Interpol abuse and defending the rights of individuals on the international wanted list. My co-panelists today are Dr. Anna Ömihin of Ömihin International, based in Berlin, Germany. Dr. Ömihin also teaches at the University of Gießen, and Nicola Canestrini of Canestrini Lex, located in Rovereto, Italy. Today, we are going to discuss the European Union approach to government requests disseminated via Interpol's channels. The European Union has been heavily engaged in the issue of Interpol abuse. First and foremost, all EU member states are members of Interpol. The European Union Agency for Law Enforcement Cooperation, commonly known as Europol, cooperates with Interpol. There are, of course, EU data protection laws that apply in certain cases of government requests submitted via Interpol. And we know of several prominent cases in which countries members of the European Union detained famous individuals, well-known individuals, including European Union citizens, at requests disseminated by non-EU member countries via Interpol. Among such cases are Hamza Yelchin, I'm sorry if I'm mispronouncing the names, and Dagana Khanli, both detained in 2017 in Spain at the request submitted by Turkey. Both were European Union citizens. And in 2018, Bill Browder was also detained by the Spanish authorities, supposedly on either diffusion or red notice disseminated by Russia via Interpol. These prominent cases led to a number of developments, from the hearings on the legislative level in the European Union and individual members of the EU Parliament expressing their initiatives. And of course, the case of Hamza Yelchin and Dagana Khanli led to the famous, in the media meeting, it wasn't publicized otherwise, briefly publicized in the media meeting between the European Union delegation and Interpol, during which, according to the reports, again, published by the media, unfortunately, Interpol has not really said anything official in that, a memorandum was handed to the members of the EU delegation, according to which Interpol claimed that it was reviewing 40,000 red notices and diffusions for potentially being in violation of Interpol's rules. And of course, Angela Merkel, at the time, the head of the state in Germany during her re-election campaign, made Interpol abuse one of the issues that she considered important. And of course, jurisprudence on the EU level. It's the European Court of Justice. We're going to talk about these cases in detail today. I will ask Anna now to talk about those cases, and then we'll proceed.
Yes, thank you very much. I am just going to share my PowerPoint with you, if I manage. Just 1 second, sorry. Okay. Does it work? Do you see the presentation?
Yes, perfectly.
Okay. Yeah, so just for the non-European, non-lawyer participants, we thought it's useful to give a brief overview of the European courts that may be relevant here, because there's sometimes some confusion. There are two European courts. One is the Court of Justice of the European Union. The other one is the European Court of Human Rights. The Court of Justice is also referred to as CJEU, or previously ECJ, and it is a court of the European Union. It was set up in 1952, and it's located in Luxembourg. It's an institution of the European Union and ensures the correct interpretation and application of EU law throughout the member states. It now has 27 member states. The European Court of Human Rights, on the other hand, is a court established under the European Convention of Human Rights and has much more members and a much broader territory. It has 46 members since Russia left before it was 47, and it was set up in 1949, and it has its seat in Strasbourg. The European Court of Human Rights watches over the compliance of its member states with the European Convention on Human Rights, and that means basically the human rights enshrined in this convention. Here you can see the geographical difference. The pink Russia is a former member state of the European Court of Human Rights, not anymore. And the gray one in the middle on the right is Belarus. So we want to show you in one example case that is a recent case of last year that was quite groundbreaking or landmark decision because it shows you how much influence the European Court of Justice, not so the one in Luxembourg, of the European Union has on even Interpol red notices. The case is called WS versus Germany. And here we have WS. He was subject to criminal proceedings in Germany for corruption allegations. And in 2010, the proceedings discontinued on the basis of an agreement and under the condition that WS paid a sum of money. And this kind of closure of proceedings, it's under section 153A of the German Code of Criminal Procedure, is under German law a final decision. That means you cannot be judged again on the basis of the same facts if you have closed the case under section 153A. So under German law, the principle that you cannot be tried for the same offense impeded another conviction in Germany. Then came a red notice from the US. And in US, there were also proceedings against WS. And these proceedings actually concerned the same acts that had already been subject to the proceedings in Germany. So in 2013, the German Federal Police, the BKA, arranged an addendum to the red notice, so to Interpol, in which it stated that the BKA considers that Mr. WS has already been tried in Germany. So that's a principle of nebis in idem, which means basically that you cannot be tried or punished twice for the same facts, should apply to this red notice against him. This was done in order to prevent that he could be arrested in other European member states. Now, in the year 2017, WS complained with the Administrative Court of Wiesbaden and applied to that the red notice should be withdrawn from Interpol. So not only not enforced in Germany, but withdrawn totally. And he argued that the red notice violated the principle of nebis in idem, which is enshrined in Article 54 of the Schengen Agreement, called CISA, or Article 50 of the Fundamental Rights Charter of Fundamental Rights of the European Union. He also relied on Article 21 of the Treaty of the European Union on the functioning of the European Union, which is the freedom of movement, because based on this red notice, he wasn't unable to leave Germany. Additionally, in the complaint, he considered that the processing of its data through Interpol was not in compliance with European data protection law. The Wiesbaden court, instead of deciding on the action, referred the case in a preliminary ruling. This is a typical ruling that has been established by the Court of Justice in order to harmonize European law, to the European Court of Justice in July 2019. And they basically wanted to find out whether these provisions on nebis in idem and on the freedom of movement actually precluded WS's arrest by a member state of a person subject to the red notice from a third state, provided that that person had already been subject to criminal proceedings in one of the member states of either Schengen or the European Union, which have been discontinued after the person fulfilled certain conditions, here the payment of a sum of money, and under the condition that the authorities of that member state have informed Interpol that these proceedings relate to the same facts as the facts that are described in the red notice. So, in a nutshell, the Wiesbaden court asked the European court whether the nebis in idem rules precluded that Mr. WS could be arrested within the European Union or within the whole Schengen area, actually. The other question that was posed concerned the Data Protection Directive 2016-680, in asking whether the relevant provisions of that directive should be interpreted as meaning that member states are obliged to introduce legislation that, in the event of proceedings whereby further prosecution is barred in all member states, further processing of red notices is prohibited. So in case that the court comes to the conclusion that WS cannot be arrested in any member state, whether then also the processing of his data through Interpol and through the member states should be prohibited. And finally, the question was also whether an international organization such as Interpol has an adequate data protection level. The questions in the referrals to the Court of Justice are usually very, very long, so I have taken the liberty to summarize them a little bit. Otherwise, it would be unbearable in PowerPoint. 2 months after the preliminary ruling was referred, the red notice was actually deleted by the United States. Then the question was, is the case still admissible? And there were many countries participating with their opinion and challenging the admissibility. One of the main reasons was actually this one, that there was no red notice more, so they considered it not relevant. However, WS argued that under German law, it was still relevant because he had changed his administrative action into an action to declare how the legal situation now is. So declare that he cannot be prosecuted again in another member state. The European Court of Justice found that the question 1 to 4 were admissible, and also question 6. So all those questions relating to the nebis in idem provisions were admissible. The question regarding data protection, regarding the question whether Interpol possessed an adequate level of data protection was not admissible because the court found there was not enough connection to the case at hand. In substance, and this was the important thing, the court stated that the nebis in idem principle under Schengen and European Union law does not preclude a provisional arrest unless it is established in a final decision taken in a member state that the trial of that person in respect of the same acts as those that are in the red notice has already been disposed of by a member state. In other words, it does preclude the provisional arrest if you have a judicial decision of a member state which establishes that the facts in the red notices are the same facts that have already been tried finally in a member state. With regard to the data protection question, the court stated that the provisions must be interpreted as not precluding the processing of personal data appearing in a red notice in the case where it has not been established in a final decision taken in a member state that the nebis in idem principle applies in respect of the acts on which that notice is based, provided that such processing satisfies the conditions laid down by that directive. In other words, double negation makes it a bit more complicated to understand, but he said as long as there's no final judicial decision on that it is actually a nebis in idem case, the red notice, and has already been decided on in the member state, finally, as long as you don't have a judicial decision on that, data protection law is not infringed, and the processing of personal data through Interpol is thus possible. So, in other words, the application of the nebis in idem principle now can actually preclude the arrest in another member state based on the red notice from a third state. Before, this was only possible within the member states, but only if a final decision has been made in a court in another member state, or in the same member state also. And a judicial decision confirms that this nebis in idem principle applies to the facts of the red notice. Problems related to this decision. Maybe before I come to the problems, just briefly, the advantages, the great advantages, and the reason why this is a landmark decision is because the nebis in idem principle, which is a principle known in every jurisdiction, in most jurisdictions of the world, but only national-wide, has now been extended to third country nationals within the European Union, but third country nationals, when they are in the European Union, they can enjoy this principle. The problem is that you need this judicial decision, and to get that judicial decision that establishes that it is really a nebis in idem case is not so easy, because the red notices are often very vague, and the facts written in the red notice may not be enough to verify whether it's really the same facts as the ones in the decision that has already been, in the case that has already been decided. So this is one problem, and it is then up to the concerned person to prove that it's really the same facts, and he has then to go to the third member state and get the facts from there, and then it depends on how much access he has to the facts and how much advanced the investigations are, whether he can really get these facts or not. The other problem, which is at the moment even maybe more problematic, is how do you get such a judicial decision? The Court of the European Union, in its margin number 92, stated that all member states need to provide a legislative way to or provide legislation to obtain such a decision on the finality of the case. However, in German law, we don't have such a legislative process yet. So there's actually no way at the moment, until our law is changed, to actually apply and implement the case law of the European Union, unless you argue that courts are obliged to obey and implement and apply case law of the European Union, and therefore, even if there's not such procedure established, they need to apply the procedure they have analogously, by way of analogy. The other question that is still left open in this case is what happens now if you get such a judicial decision? Is then the processing of data infringing data protection law. This is something that the European Court has not clarified. But this is not the last word of the court, and I'm happy to hand over to Nicola to continue the story of European Union approach to the red notice. Thank you very much for your attention.
Yuri, may I take over?
Yes, please. Yes, and
yes,
of
thanks
course.
again for inviting me again. It's always a pleasure to share thoughts between interested and prepared people. So this is indeed the story I'm going to tell about is indeed the continuation, the continuing story from WS. I'm going to comment the another decision who is called HF. Mr. HF is a Serbian national who was not a citizen of the European Union. But this is important to state it. Serbian nationals have no visa requirements when they travel to European Union. He had an Interpol red notice pending over his head, and when he entered Germany, he was arrested in January 2022. He got arrested with the extradition request from the US. The fact was that Mr. HF has been already put under trial, and has been convicted by a member state of European Union, and especially by Slovenia. And the conviction was allegedly given for same facts. To be more precise, he was convicted for part of same facts being part of the extradition request, and from the other part, the Slovenian authorities stated that there was no offense committed. So in any case, there was a judicial decision about the same facts regarding the extradition request. So when he got arrested and the extradition request was pending, it is important to note that Germany had an extradition agreement with the United States of America. And there was a consideration of an bis in idem principle, but covering only the decisions of these two governments, so states, so Germany and US decisions, not mentioning third country decisions. As Anna already mentioned, the bis in idem principle has a domestic effect, precluding that in the same state someone is tried or convicted for same facts again. Has an international perspective, where it is important to note that the bis in idem principle is not a generally recognized principle, an internationally generalized principle. So it could be that someone is going to be tried and convicted twice for same facts, unless there are agreements in place who prevents this double jeopardy or double conviction. And the third thing, on European, there is a conventional, so regarding the big Europe, let's say, dimension of bis in idem principle, since there is an additional protocol to the European Convention of Human Rights, which is not relevant at this point. But what is relevant is this fourth dimension, so the bis in idem principle on EU level. And this bis in idem principle on EU level is based essentially on two provisions. The first one is the Article 50 of the Charter, which says that no one means no one. Somebody stated in Anna Ömichen's case, it was Advocate General Collins, I think, in your case, Anna, stating that no one means no one. So it makes no difference if somebody is foreigner or a citizen or citizens of another EU member states. And the second provision, which is important to recall, is the Article 54 of the Convention implementing the Schengen Agreement. Schengen Agreement was the agreement from which the freedom of movement between the European Union was, in which the freedom of movement was born, establishing the free movement between the member states. It grew, and Article 54 of that convention implementing the Schengen Agreement states that a person who was finally disposed by the judicial authority of one of the member states cannot prosecuted, that's the term of Article 54, in any other member state if the sentence has been enforced. So fact is that in our case, Mr. HF had been already sentenced in Slovenia, so a member state. He served in full his conviction, and an extradition request coming from the US for those facts had been already refused by Slovenia. What are the difference to WS case, which Anna Oemichen spoke about a couple of minutes ago? It is a third country decision here, so it is it was a third country national. Sorry, so it was a Serbian national. There was a formal extradition request, not only Interpol red notice. There was an obligation to extradite because Germany had this extradition agreement with the US in place, which put the duty on Germany to extradite. And so the German referring court was asking the Luxembourg court, if I extradite, I may infringe union law, but if I don't extradite, I may infringe the US extradition agreement. And the limitation of the extradition between this agreement was ruled only for judgments of one of these two member states, of these two states part of the agreement. So third states decisions were not considered in the extradition agreement itself. In the case of October of last year, so it took the court less than approximately 10 months to rule, a couple of days more than 10 months to rule in this case, because it was an urgent case, because the defendant was in custody. So it was a PPU case, an urgent procedure. The court said the Article 54 of the Convention implementing the Schengen Agreement, read in light of Article 50 of the Charter, covers even extradition requests, because remember, the Article 54 stated that it applied only to prosecution, but the court and the Advocate General stated that the extradition request should be covered by Article 54 of the Convention implementing the Schengen Agreement as well. It covers everybody, not only European Union citizens. It covers even non-EU nationals. But what is most important in my point of view, even if the stay of the non-EU citizen in one of the EU member states is unlawful, because it is basically no limitation in the wording of the text can be taken in order to limit Article 54 of the CISA and the Article 50 of the Charter in order to preclude its application to unlawful residing people in one of the member states of the European Union, and because, of course, it is a fundamental right, and in such it applies even if the stay is unlawful. Then the court said the EU, so there is an agreement in place between Germany and the United States. This agreement had a particular procedure in trying to make the two subscribing parties communicate when there is a particular or a special procedure, when there is a special event, when there is a special thing to consider, so the two governments could have a kind of exchange of information, as in the usual extradition requests or proceedings. And so the fact that there was that the judgment being on the bottom of an extradition refusal only if German courts had ruled was not that binding for the parties, because they could have exchanged information in order to find a solution, even if there was a problem in extradition. And which is much is more important, there is a primacy of EU law. So since there is this primacy, which means that if that the national rules have to be interpreted in light of the EU law, but if there is a contradiction between national rules and EU law, the EU law must prevail. And this has been affirmed by the Court of Justice with a view to extradition. It is the view of nebis in idem, with the nebis in idem principle as well. It's a 2018 case, which is not a criminal case, but it does apply in any case. So the direct effect of EU law, so the primacy of EU law, is going to go beyond and be stronger than the national law. Then the court turned and reaffirmed and affirmed again what's the factual basis of this nebis in idem, which are identical facts. What does identical facts mean in the view of the Court of Justice in Luxembourg? They have to be the same events in essence, says the court, the same perpetrator, and these events have to be inextricably linked in space and time. And if this applies, this is the conclusion of the court, the extradition to a third country, of a third country national to a third country, not being European Union, so is precluded if this national has been convicted and served his sentence in full, and even if the nebis in idem principle application is limited for one of the only for judgments in the contracting in the contracting states. The conclusion of the Court of Justice is one brick in the wall, which the Court of Justice is building in relation to extradition, nebis in idem, and Interpol, red notice effect in European Union. You may consider that in our 27 member states, there are different effects of the Interpol red notices, and of course, different provisions regarding the nebis in idem. Regarding Italy, this conclusion is not a new conclusion, because we already had, and I fought a case before the Italian Supreme Court in 2016. There was a third country national who export. May I speak about that, Yuri, now?
Yeah, yeah, sure.
Okay.
But yeah, if I may ask you just briefly, because we need to move on.
Yes, very shortly. The guy was had an Interpol red notice from Turkey because he was a drug dealer, and he left Turkey with a certain amount of drug. He imported same drug in Germany. He was caught there. He was convicted in Germany, and then he traveled to Italy and was arrested on the basis of this Interpol red notice from Turkey. And the defense, so me, objected that there was the nebis in idem principle on EU level, because mutual trust means mutual trust, even if there is even if it's used for upholding the rights of the defendant, not only when it's going to uphold the prosecution or the state authorities' reason. And the Supreme Court ruling in November 2016 stated that a decision of a EU member state based on Article 54 of the Convention implementing a Shambering Agreement, in fact, precludes the extradition to another country even if the decision being ground of the nebis in idem effect is not an Italian decision, but decision of another EU member state. Thanks a lot, Yuri.
Yeah, sure. No, thanks, Anna and Nicola. So I find it interesting that when we talk about, and that's been the case, I guess, for years now, when we talk about the EU jurisprudence and Interpol abuse, and we consider specific cases, they all somehow end up with the principle of nibis in idem. So it seems like for whatever reason, the European Court of Justice has not opined on otherwise unlawful Interpol requests. Nibis in idem has been at the center of all of it, and it's by far one of my favorite topics when it comes to Interpol abuse, probably because it's so complicated. I've been studying it for a while, so we need to do a separate webinar on that, in my opinion, just on that topic because it's so complicated. And but I'll still throw this in. So Interpol, the Commission for the Control of Interpol's Files, has published two decision excerpts in which it explains, or it thinks it explains, how it applies nibis in idem with regard to government requests submitted by Interpol's channels, and they contradict each other. One decision says that nibis in idem doesn't apply to Interpol requests, and the other one says no, it's actually possible. So it's still, but let's not get caught in there. So let's talk about the EU approach to red notices, and try to go beyond nibis in idem for a second. So it seems to me that despite there was a debate in the European Union Parliament back in 2017 when there is a video published during that hearing, a debate. I'm sorry, several politicians, members of the parliament representing different countries, say that no, a red notice or rediffusion should not be a reason for the reason for extradition, which is pretty much the same approach that the United States has taken, except in practice, a red notice and rediffusion plus some additional information. It doesn't matter how minimum that additional information is, may easily lead to detention and potential extradition. But it doesn't seem like, despite the fact that there was this debate, at least one debate, that several EU politicians have raised this issue. There have been reports published by some of them. They've studied it. Again, as I mentioned, Angela Merkel made it part of her election campaign, and so forth. But it doesn't seem like there's been any specific legislation considered on the EU level to somehow circumvent Interpol abuse, at least more or less. Why do you think this is the case? Because the data protection directive that WS refers to, it is a general data protection piece of legislation. It's not really specifically related to Interpol, and its provisions, in my opinion, are too vague for that particular topic for the issue of Interpol abuse. As long as data is lawful, it can be processed. And WS versus Germany, to me, and please tell me if I'm wrong, but to me still seems like sort of like a half measure, because the European Court of Justice in WS, that's how I understand that decision, says that, well, if a country is aware, if a country executing a request submitted to Interpol's channels is aware that there is a decision, that judgment in nibis in idem applies, then they should not be processing this information. But they can still process this information in at least two instances. First, to confirm that nibis in idem applies, which means that the person can still be detained until the executing country figures out if nibis in idem applies in his or her case. And then WS versus Germany also says, that's again my understanding of it, that that they can still process this information even if they know that nibis in idem applies, except there must be some addendum explanation that the person cannot be prosecuted in an EU member country, which to me again seems like something that might easily lead to detention, no matter how short it is. But still, let's start. I'm sorry, it's a long question, but let's start with legislative initiatives. Are you aware of anything on the EU level specifically regarding Interpol abuse? Either Anna or Nicole, please.
No, maybe Anna, please.
I'm also not aware of any legislative approaches to work on that. It's even worse. The question whether Interpol could be held liable under any of the European courts is a question still unsolved.
Right. Well, that's a question of immunity. We will definitely talk about it in one of our future webinars, for sure. But so it's neither even in just on a national level, either Germany or Italy, there have been never proposals, legislative proposals to fight Interpol abuse specifically, right?
No, even worse, Yuri, because Italy does consider the mere Interpol red notice as a request for provisional arrest, meaning that somebody who is targeted with an Interpol red notice, who is, for example, who comes to Italy for tourism or for visiting or for professional reasons and stays in a hotel, is going to be arrested in the early morning of his first night, because Italy's hotel system is linked to the police database, which is linked to the Interpol red notice and the Schengen information system too as well, which is the European database for provisional arrest for requests. And somebody gets arrested right away with no chance to have any idea why she or he got arrested until the extradition request comes in. And similar to the European Convention of Extradition, many bilateral extradition agreements give Italy and the other states with which Italy has an extradition agreement up to 40 days for filing the extradition request. That means that somebody can be arrested in Italy only because a little red light shows up in the police station. And if the client would like to know, or the defendant or the arrested people asks the lawyer, why have I been arrested? The only answer is because there is an Interpol red notice, and the Interpol red notice, we know it's 3 or 4 lines of description of the alleged conduct. So you don't have any chance to get the information before the extradition request comes in. So there is not only no Italian or European attempt to limit the possible abuse of Interpol red notices, but worse than that, there is no judicial control, effective judicial control when executing a red notice. So red notices are executed automatically, no matter if there is another conviction in another EU member state, which is today's topic. And this is going to be researched and assessed during the extradition proceeding, but it takes the courts months in order to assess that. And the defendant, who in our case with another decision covering same facts and having fully served this decision, stays in jail until the nibis in idem basis for application of the principle is completely fulfilled, and somebody is detained only because there is a red notice. That's it.
And do you have in Italy proceedings to establish this nibis in idem application to the red notice?
Yes, it's usually directed not against Interpol, because to my knowledge, Interpol should at least have a little mark, a little star on the red notice saying that somebody has already been tried or convicted in whichever state, in order to make the police authorities aware that there may be a nibis in idem problem. but it's the ne bis in idem, assessing the ne bis in idem principle during the proceeding is possible only during the extradition proceeding. So we go.
Okay, but at least then you have a proceeding to establish this
Yeah.
ne bis in idem, and then based on that you could refuse extradition. Because from what I understood now, my colleague who fought this case, WS by the way, and also the other one is today present, he told me that in Germany we don't even have proceedings to establish the ne bis in idem at the moment. So there's actually the decision of the European Court cannot be applied at present. There is no final decision that declares that the case has been finally decided, except for the final decision, but that is not enough for the CJEU.
Okay, no, we don't have a specific ne bis in idem procedure. We have the extradition procedure in which the defense can file its motions, and of course, ne bis in idem principle is one of the reasons why the defense could oppose surrender or extradition.
But it's already, I think, quite an achievement that your Italian court respects a final decision of another member state, because there also German courts are quite reluctant and think just because another country found that that person has already been punished, this doesn't mean that we assess it the same way. So the principle of mutual recognition doesn't work in that direction. It's a one-way route at the moment.
Yeah, but again, here I'm a little bit provocative, of course. Hi, Vanya. I'm a little bit provocative because mutual trust works both ways. It's not only, and mutual recognition is based on mutual trust. And if you would like to trust somebody, you on European Union level, it's established that it's the rights, the knowledge that somebody respects the rights of the person in every member state, and that goes both ways, not only for executing convictions or for requesting the surrender for prosecution. It should be the other way around as well. If a court in Italy, Germany, Portugal, or Slovenia assesses that somebody has been convicted or has been acquitted, this should go directly in this mutual recognition procedure. I know maybe sometimes judges and prosecutors are very confident in another member state's prison system because there should be mutual trust, and a little bit less confident that an acquittal abroad is really fair.
I just want to our audience, please feel free to ask questions in the chat. We'll happily answer if we can. But let's say somebody has his red notice removed or diffusion by Interpol following the CCF ruling, declaring it, for example, in violation of Article 3, is predominantly politically motivated, and there is still old data in the EU hanging somewhere there in at least one of those countries, based on which we can still get detained, despite the fact that Interpol has already informed that country that the information is non-compliant with Interpol's rules. That's happened. So again, allegedly, that's how Bill Browder got detained back in 2018, I believe, right, in Spain. So if this is the case, that same, again, if we apply WS versus Germany, it seems to me, despite that data protection directive, under WS versus Germany, the country can still say, we will keep this information in our database. We know it's unlawful. We will just add, sort of like there'll be an addendum saying that Interpol has decided that it's in violation of Article 3 of its rules, and still keep it in the database. To me, as an Interpol defense lawyer, and I'm sure you guys have seen the same situations, a government official, border patrol officer, for example, when they see an Interpol alert when somebody tries to cross a border, it's often the reason for detaining that person. Again, it's a question how long that detention will last, but nevertheless. So it seems like, to me, again, please tell me if I'm wrong, but to me it seems like if we apply WS versus Germany, it's up to that country to keep that information in the database, even if it's old, even if it's non-compliant, or to delete it. It's not like the EU countries have to delete this information if it's in violation of Nibis in idem, or if it's in violation of, if it's against the ruling that CCF has handed down in that specific case. Is that right, or am I wrong?
What we do have is the possibility to flag a red notice, and this we already had before the case WS. And in the case WS, actually, the German Federal Police had flagged the red notice and had put a note on the red notice stating that in Germany he could not be tried because he had already been tried for the same facts.
Right.
So this exists, and the question now, whether the data should be deleted in all the police databases once we have a decision that refuses extradition to a third country based on nebis in idem, is a decision that hasn't been clarified yet. So we don't know how the CJEU would decide in that instance. It's possible that then he says then it should be deleted. But the interesting part is also that in that sense, the court found that it actually does apply to Interpol, that Interpol is bound also by the directives. This is what I find interesting also.
You mean in WS?
Yeah, they discussed it at least, which means implicitly that they didn't exclude the applicability of the directive in general to Interpol.
So my understanding of what they said, I don't, it was that the European Court of Justice, they did say that Interpol is not bound by the directive because it's not, it wasn't party to it's not party to the European Union. But in that I found, I agree with that. But what's interesting is that there have been a number of instances of the heads of CCF during the General Assembly meetings, asking member countries to cooperate with CCF because otherwise Interpol would be, if not in violation, sort of its activities would be contrary to modern data protection laws. I don't think that they specifically mentioned the EU, but I think that's what they meant, because I think the EU probably has the most modern, comprehensive data protection laws than many other countries. So I think Interpol realizes the importance of the directive, even though if it's not bound by it, but still. So is it true that if taking into consideration WS, taking into consideration the HF, the case that Nicola has just told us about, they can still retain the information in the database just with an explanation, like that it's unlawful, that the person cannot be prosecuted, and so forth. So there is no mandatory deletion of that information.
No, because as we know, to delete Interpol red notice, there are only two known ways. One is the fact that the member state who put it in the system is going to raise it. The second one is the CCF, and I'm not aware about the procedure which allows another member state other than the one who put the red notice in the system can erase it even only on its own national within its national borders. But I would like, Yuri, if you allow, Søren Schomburg, who is the colleague who fought those cases in Luxembourg, says exactly in the comment.
Oh yeah, of course. We'll move to the questions in just 1 second. I just wanted to mention that again, it is my understanding. Please correct me if I'm wrong. I think this is important. I just wanted to make this point. So, say if you are a third party national, not an EU citizen, and you obtain a decision from the CCF saying that the red notice of diffusion against you is in violation of Interpol's rules, for example, again, predominantly politically motivated, you can, it seems like you can still ask, because there is no guarantee that all the countries, again, if we go back to these cases that happened in Spain is probably infamous for many of those detentions, including at least some of them, including the EU citizens. It's probably advisable to communicate to any of those EU countries where you're planning to travel to, ask them to somehow at least amend their database so that you are, hopefully, if you are detained, not for a long period of time. Let's move to the sure, go ahead.
And I think that's a good moment to move to the comment of Sören, thank you, Sören, who's actually the colleague I referred to who fought these cases. That this is why what you should do preventively, you should first get a judicial decision that establishes that nebis in idem applies to this red notice before you start traveling. And in addition, as I agree with you, check with the national databases if they have really implemented the deletion or this ruling actually. So and there really the problem is, and this is something I would like to also ask to the audience, are there any countries who have already implemented this requirement of the European Court to establish such a procedure whereby you can assess whether the facts are identical? So a specific nebis in idem procedure is actually required by the European Court of Justice. And I'm not aware of any country who has already introduced that, but maybe someone here.
Yeah, but please let us know. It would be incredibly interesting. Let's move to questions. I'm sorry. So Søren Schomburg, I'm sorry if in advance, I apologize if I mispronounce anybody's name. The central point is that member states have to introduce a procedure whereby you can assess whether the facts are identical. This should enable a citizen to know whether he or she will be arrested, whether the request concerns identical facts, only in that way. So that again concerns nebis in idem. I agree. The problem again with nebis in idem, it's an incredibly complicated topic. I mean, on the EU level, there is some unification, and because I've been studying this issue, and I believe at some point even the European Court of Justice and the European Court of Human Rights disagreed with each other. I mean, they fixed it kind of later, but it's still a pretty complicated topic. But thank you for your comment. I agree. And I think we will agree. Vanya, there is no controversy about the application of EU data protection rules to Interpol, but I believe the ground position is that it may not apply, but Interpol needs to apply it. Yes, again, right. So we talked about it, right? Like, please, and Nicola, feel free to comment on that. As I said, I think that Interpol refers to EU data protection laws when it wants member countries to communicate with CCF.
Maybe something to make this conversation a bit more open also for non-Europeans is that I think what we can say is that the recent years, the case law of the European Court of Justice, also in other cases like Petruhin, etc., has started to establish a minimum level of protection within the European Union.
Right. Well, I mean, I understand like third-party nationals traveling to the European Union. I mean, they're not subject to data protection laws. They really cannot claim.
Yes, they are in the European Union. Yes, even if they are not national. That was the main point of the case.
Oh no, right. That's but that's nebis in idem when one of the countries members of the European Union has already opined on that specific case. That makes sense. I mean, the person has been under jurisdiction of one of those countries. But say let's go beyond nebis in idem in this country, because nebis in idem really drags us into this. Is I think because again there are no other cases by either European Court of Justice or European Court of Human Rights concerning Interpol, but nebis in idem so far. But say beyond nebis in idem, you're just a third party national. You've never been prosecuted by any of the EU countries, and you have, you cannot really claim that EU data protection laws should somehow cover you. So I mean, it's not really something that they can enjoy. The third country nationals can enjoy. That's unfortunately. So that if Vanya writes, there is no procedure in Portugal except being arrested in an extradition case and obtaining a decision.
Well, Vanya commented on this data protection question in her earlier comment. So she says that that's controversial, and she's right. I was maybe a bit too optimistic to understand WS in that it really makes the directive applicable to Interpol. However, what is also right is that anybody who is under the jurisdiction of the European Court needs to have at least an adequate data protection level as the European Union. The same applies also to the UK. There needs to be an adequacy decision to make sure that data protection with that institution is not below the European level.
Sorry, Yuri, may I add something?
Of course.
It's true that data protection applies primarily to EU citizens, but you have a foreigner resident in the EU, data protection does apply.
Yeah.
European data protection does apply to non-EU citizens as well if they're resident within the EU.
Right. That's I agree. So as long as you become because I think that's what WS said as well, right? As long as you are detained, that already means prosecution.
Yeah.
So that's why you now under the EU jurisdiction. But before you are detained, like before you decide to travel,
are you also under jurisdiction?
Even though you've not, just because they process the information about you. Okay, so that's
the territorial scope, not the personal scope. Then
exactly.
I see. That's important. That's really interesting. But again, there is no. So is it, say again, in the third country national? I'm sorry. Before traveling to the EU, you can ask the country you're going to, the country member of the European Union, to. I mean, you can ask the question is, do they have to do it to amend whatever data they have in the data, at least amend whatever data they have in the database, to make sure that you're not detained or the chance is really small. Is there a way to somehow minimize the threat of being detained if you travel there, if you have a decision by CCF saying that the red notice infusion has been removed?
A little bit easier in Italy. I would just advise the client to bring the CCF letter with him or her, because this would help to be subject to stay in the police offices of the city where you're traveling to for a couple of hours until police clears that with the Interpol National Bureau. Because in Italy, if you are going to be, I don't know, if you check in a hotel in Venice, then there is an Interpol red notice, the Venice police will show up. They will bring you to the police headquarters in Venice. If you have this CCF letter, they will consult the Italian National Bureau. If they confirm that there is the Interpol red notice, which shows up in national system but is not longer in the Interpol system, you're not going to be arrested and you're not going to be subject to extradition proceeding without a prior judicial decision, national judicial decision, that there is no that you cannot be arrested in Italy. So a little bit easier and with no need to have to consult a lawyer before coming to Italy. Just be sure to have this decision in your pocket when you.
But for all other countries, I agree with Yuri. I would advise to first check in this country concerned, just to be safe, because also it's not so much fun to be in the police station for hours for them to check the paperwork, whether it's true that, or whether your paper is maybe a fraud.
But so, Anna, can I ask the Bundeskriminalamt, for example, if there is a red notice against me?
You can ask the Bundeskriminalamt whether there are any personal data on you stored in their police databases.
Interesting. Italy would ask Interpol.
Or Italy would ask Interpol if they can release this information.
Again, sorry.
Yes.
You said probably would ask Interpol whether it can release this information.
Yeah, probably. Yeah, probably.
This is interesting. Yeah. So and then Interpol would probably ask the country that submitted this information. Convoluted process. Vanya, in respect of CCF decisions, my experience in Portugal is that it may impact the arrest on the basis of the red notice, which should not be implemented following the CCF decision, but it will not prevent the detention on the basis of an extradition request or a direct request for detention with the view to extradition. Does not apply to request. Yeah. So
Okay.
So, in other words, if there is a Vanya, please correct me if I'm wrong. So if I understood you correctly, so in other words, if a red notice has been removed in Portugal, if the red notice has been removed, but there is still an outstanding request for extradition of that same person that has been submitted to to Portuguese authorities, they can still detain that person just based on that request, despite the fact that they might very well be aware that the red notice, based on that same charge, has been removed, right? Yeah, that's unfortunate. Yeah,
I must relativize my answer so that you don't get the wrong impression from German policemen. Of course, if they want to catch you and you write such a request to the Bundeskriminalamt asking for your personal data, the Bundeskriminalamt can also either take a long time to answer or simply say we cannot give you any information, but they will answer. And if they cannot give you any information, the answer is quite clear also, maybe. So
yeah. Well, I mean, it's pretty clear that the EU approach is at best hasn't been clarified yet. It's not necessarily negative towards the victims of abuse, but it's definitely not clear, and it definitely seems to me very complicated. But of course, I mean, if we go back to all this debates that happened before, I haven't really heard anything in the past couple of years from the EU, from the members of the European Parliament. I mean the politicians themselves, much on Interpol abuse. It was usually it's around like 2017, 2019, 2020 when somebody said something, and it seems like the issue kind of died out for them, because I haven't seen any reports from individual politicians in the past couple of years. Hopefully they'll come back to it, but I don't think that from what we discussed today, it doesn't seem to me like the European Court of Justice or the European Court of Human Rights, the European judiciary in general, on the national level, on the EU level, on the union level, can resolve this without the EU Parliament's involvement. It just doesn't seem like this is something that might happen. And obviously, current data protection laws in the EU aren't really enough. I mean, they're clearly better than I think here in the United States in this regard. But no, they really are. I think in terms of data protection, at least when it applies to Interpol, it seems to me like EU citizens can obtain much more. They have many more chances to get some relief than here in the United States.
But we are fighting hard, Yuri. Don't underestimate our defense attorneys. We are trying to keep the ball rolling, and at least we will score the goal.
Yeah, no, of course. I think it seems like we have no more questions from the audience. We've covered a lot today. It's a complicated topic. Next week, we are going to have our next webinar is going to take place next week. We couldn't do it last month. It was scheduling conflicts. It's going to be Jago Russell, formerly Fair Trials International, Michelle Esland, and me. We will discuss the Interpol reforms of 2017. I will post the link shortly. If you are willing to attend, we hope you're going to be there, and I expect it to be a very interesting discussion. And then after that, as we discussed today, we will cover in our next webinar. We'll after Michelle and Jago, hopefully with Anna and Nicola, we will talk about Interpol's immunity. Thank you very much again for attending the webinar. Thank you, Anna and Nicola. It's been a pleasure, incredibly interesting, and let's do it again.
Thank you very much, Yuri. Thank you, Vanya and Sören, for your contributions. Thank you, Nicola. And yeah, we look forward to your next webinar. Thanks.
Yeah. Ciao. Grazie. Ciao.
Thank
Grazie.
you.
Ciao, Vanya.
Ciao.
Ciao, Yuri. Anna.
Thank you.